Hi everyone, and welcome back to this week's episode of Digital Law News. So this episode is brought to you by Digital Law and Anson Evaluate. So just for those who don't know, Digital Law is a niche law firm based in the UK, and we specialise in all things to do with data, cyber law, and anything to do with technology matters as well. So I'll just pass over to Peter, my colleague, to introduce himself before we get started.
Thank you, Laura. My name is Peter. I'm the Solicitor and Managing Director at Digital Law, and it has indeed been a busy week with more information with regards to hacks that are taking place out there, as well as some interesting discussions around future data protection regulations. So I'll pass back to Laura to take us through that.
Great, thanks, Peter. So starting with the first story of this week then. So this is in relation to a security camera hack, so CCTV. So 150,000 cameras have actually been hacked into at a Silicon Valley security firm. So these include video footage showing inside prisons, police stations, schools, and a Tesla assembly line as well in a factory. So the hackers have supposedly gained access to live feeds of these cameras occupied by Verkada, and the systems have basically these cameras are controlled remotely and exercise the use of facial technology, facial recognition technology as well. So a high amount of personal data on there. So it seems to be that a Swiss software developer called Tilly Kottmann has actually done this as kind of a way to fish out the bag of eggs, as you say, to expose the threats that is happening with these security cameras. But I'm not sure if that has been confirmed yet.
Thanks, Laura. I think this story is absolutely fascinating, and it illustrates some advice that we always give to all of our clients when we're carrying out a full-on data protection assessment for them. And when I say a full-on assessment, that's sometimes where we go in and look at an organization's infrastructure, everything from how their IT works to actually going into their office, looking at where papers are stored. And this could be quite an interesting exercise. I mean, before now, I found one organization had a bank vault in the basement they used to use to store all their archives in, and it turned out that the lock on the door never worked, and it was now held together by a padlock, and you could anyone basically could walk into this building, walk down into the basement and go into this safe and see this archive. But the point is that there's lots of stuff that organizations tend to overlook when it comes to how they look after their data, and CCTV is always a wide open gaping hole. Because they're not actually thinking that it's important, because everyone thinks, oh, it's just the CCTV. And they might sort of, create very secure databases to look after things like client data. And then the CCTV is just an afterthought, when CCTV, surprise, surprise, contains personal data. I mean, if you've got, say, a CCTV camera in your organization's car park, that is recording people coming and going from your organization, and important data like number plates, potentially. If you've got CCTV in a shop doorway, when the shops are back open, of course, and you can then potentially see people coming and going. Or if it's a restaurant, it might even watch as people end up entering their chip and pin information. And indeed, one restaurant was closed down when their chip and pin info was being recorded on CCTV, being backed up into the cloud, and was freely available for loads of people to see it. And the point here is that we increasingly have CCTV in our offices, in our workplaces, and either we're not aware of the fact it's there, or it's there and it's not really having much done in terms of the security protocols around. And in this instance, even organizations like Tesla and others in the tech capital of the world have got all of this CCTV, and it looks like it can be fairly easily compromised. I mean, it looks from this instance like the hacker found the username and password for an administration account that was being published online. So very easy for them to then gain access and get into all of these systems. And the other thing I think it's important to make clear is that certainly when these systems are installed by third-party contractors, very often they are very easy to access. I remember seeing a very proud CCTV installer at an event once, and he was saying, look, you can look at the CCTV anytime on your phone. I'll access now a camera that I put in for someone a few weeks back, and sure enough, they were able to just enter a login and password, and you got live real-time feed on that CCTV on their phone from a camera that was hundreds of miles away. Now, that raises security issues, because then that meant anyone could potentially go in there and look at this stuff when it should have been the customer who could access it and no one else really. But if it's just been either put up onto the cloud and live streamed for anyone to look at, or just being put onto your own server but open so that anyone could potentially access it, you are in effect breaking the law. You're breaking GDPR because you aren't looking after your personal data, and this shows the danger of that. So I think it's a timely reminder of making sure that when you're looking at the data across your whole estate, CCTV is a big part of that.
Yeah, absolutely. I think that what you mentioned about having being able to see it remotely kind of links back to the advice we gave about voicemails as well. People think that being able to listen to your voicemail on your computer, wherever you are, from your desktop at home or in the office, rather than just from the handset, is better in terms of you can access it wherever, but it just opens up that additional security issue in terms of if you can access it wherever, how many other people can access it wherever. So I just think it's about that. And I think the CCTV in general as well. I saw an interesting story on the news of a day, how a lot of people are having CCTV at the homes and not realising that because it is then videoing members of the public as they're walking by, and it's not secure and things like that, the GDPR does apply. And I think a lot of people think that because they're having it in their home and they think it's not capturing other people, and it is, forgetting that GDPR applies. So I think it's, in general, I think a lot of people need to look at the CCTV systems and think, what information are they collecting, and have they got protections in place, and are they actually sticking to the rules in GDPR as well?
Yes, because then it can be, I think, a bit of a rude surprise if they suddenly find that that information has been breached and has been seen by a third party, because then it means, surprise, surprise, you've then got to report it to the Information Commissioner, you've then got to potentially notify affected data subjects, and there can be the element of monetary penalties from the ICO and civil penalties as well. And that can be a bit of a shock to people. And I'm actually thinking, I mean, you mentioned there, Laura, quite rightly about voicemail and telecoms, and I was speaking to a client a couple of weeks back who called up just to say, oh, we've got a third-party telecoms provider, and I think I've been hacked. I went, right, what are we talking about? And he took me through it, and it involved personal data. I said, yeah, that's a data protection breach. You now need to notify the ICO, and you're going to have to tell the affected data subjects. And you could tell he didn't want to do it, but I said, look, in terms of the position here, you know, as your specialist lawyer on this, I'm telling you that this is what happened. I'm actually obliged to do it. I can't turn around and say, oh, I wouldn't worry about that, because you're a data controller and you're under an obligation to report it. And furthermore, I have to make a note that I'm telling you this because I'm obliged to tell you that, you know, what the law is and what you're required to do. And it turned out he was having trouble with his supplier, who supplied the telecoms, who didn't want to report it on themselves to the ICO. But I said, what they want to do is, regardless, you're the controller, it's your data, it's been compromised, it's your responsibility, this is what you need to do. And this, as I say, this story really highlights the fact that it's important to look at the data across your whole infrastructure, your phone, your CCTV, your telecoms, the accounts, your banking. So it's not just, oh great, we've got a secure client database and that's it. It's everything across how your organization works. And yeah, we've all been working from home because of COVID in the last year, and that makes our use of these distributed systems even more important to our organizations operate, but then even more of a risk if they end up being compromised.
Yeah, absolutely. I think you summed that up great. So moving on to our next story then. So this is in relation to a story that we actually spoke about last week, and it's just kind of following on from that and basically informing you that, yeah, people have taken advantage of the insecurities that the Microsoft have found. So this is a European banking authority that have been hit by a Microsoft Exchange hack. So like I said, we warned about this last week, and the European banking authority's email servers have actually been compromised in a global Microsoft Exchange cyber hack. So it sounds like most, if not all, or a large majority of the email servers on the Microsoft Exchange have been affected by this. Yet only a few organisations have come forward so far and have said they have been affected. So it'll be interesting to see how many more come out and say that they have. So it is thought that personal data may have been accessed from its services, and the European Banking Authority have actually taken down their entire email system and taken it offline while they assess the damage as well. But some US officials have actually said that the attack remains an active threat. This article was written at the weekend, so that might have changed now, but as of the weekend it was an active threat, so just beware.
Indeed, thank you, Laura. And yeah, this does indeed follow on from that coverage we had last week on that. So again, a tiny reminder just to make sure that when you get a notification through saying that you need to install an update on your Microsoft Exchange server, make sure that goes through as quickly as possible. Because these systems are always under attack from various different sources, and it's important to make sure that all patches and updates are on there. And in this instance, I think it's interesting that the European Banking Authority obviously needs to demonstrate as a European regulator that it is complying with European law on this, so GDPR, and they have come out publicly to say, and this is the key thing here, I think a key word, which is our data may have been compromised. So they know that there's been a risk, they know that they've been on the end of this attack, they don't know for sure what data may or may not have been accessed. All they know is that their systems have been compromised, and therefore, in order to demonstrate transparency and demonstrate that they take the threat seriously, they have gone public with this. They are no doubt contacting any of the affected data subjects, and they are notifying the appropriate regulator, national data protection regulators, and they've clearly gone public, which is why this coverage was on the BBC website over the weekend. And it's quite interesting that sometimes when I've spoken to clients who are like, well, do we have to report this or not? This shows that, you know, if the system has been compromised and clearly somewhat other unauthorized third party has had access, that is a breach. And therefore it has to be reported. It doesn't matter if you can't prove exactly which records have been compromised or what has been done. I mean, you know, it's not as though you have to turn around and say, oh yes, well, these 30 records were accessed and then someone went off and used it for credit card fraud and opened MasterCard accounts using that personal data. I mean, that's clearly attributing then to the hack potential fraudulent activity, but you don't need to have that sort of clear evidence trail. It's more a matter of, have the systems been compromised? And if the answer to that is yes, that means you then have to report it, and that's exactly what the European Banking Authority has done here. They've decided we need to report this because A, it is our statutory obligation to do so, and also it's actually better to notify a data subject and say, your data has been compromised. We suggest you check your data, make sure that you know, if you've got any passwords on our systems, you may want to change your security settings and check whether you've had any phishing emails, the things purporting to come from us, all these sorts of things. You'd want to advise the data subject. But chiefly, they've wanted to get ahead of it by doing that. And it's better for the European Banking Authority to do that and be on the front foot than to turn around and go, well, let's not report it. And then the data subjects start finding, you know, their data could be published online on the dark web, as it often is, and then that could be used for fraudulent purposes, or they could start receiving lots of phishing emails purporting to come from the European Banking Authority. Who knows? The point is then it will be obvious there had been a data protection breach, and the EBA would not have notified them of it,
Yeah.
which is doubly worse than if the EBA has to go cap in hand to a regulator and go, "We're very sorry, we had a data protection breach, but we didn't tell our affected data subjects about it, and it's got really bad in the meantime." Well, guess what? More likely that you'll face financial enforcement then, whereas, you know, the regulators tend to go, if you've been open and honest and you told us in the 72 hours and you told us what the problem was and you told us what you've done to make sure this doesn't happen again and you're looking after the data subjects, they are generally more than happy to leave be in that instance. So this is a real example of good practice by the EBA and an example of what you should do if your systems are compromised.
Yeah, absolutely. I think it's all to do with limiting damage as well. Obviously, if you tell your data subjects early enough, they can then change their passwords. They can basically put the protections in place and look out for these things that might happen. For example, like fraud, there might be an account set up in their name. They can watch out for the emails looking to confirm this and things like that. Whereas if you don't tell, like you said, you're more likely to get all these issues coming from the data breach and then getting a fine from the regulator. So, yeah.
Indeed.
So moving on to the next one then, staying on the data breach and fine category. So this is 2 fines that have come from the ICO in regards to 2 marketing text pests, and they've been fined a total of £330,000 in combination of each of them. So the first fine is for Leeds Work Ltd, which have been fined £250,000 by the ICO and issued an enforcement notice ordering it to cease and desist from sending unlawful direct messaging as well. So it was found that they had contravened with Regulation 22 of the PECA, and they've been sending messages basically saying that they are Avon. So they've been working on behalf of the company Avon, sending out these messages, and I actually received quite a few of them over the lockdown period as well, basically saying if you want to earn any more money over the lockdown period, taking advantage of people basically, get in touch, and then if they receive any leads they would report back to Avon and basically follow up on the leads. And the second company, Valka Vehicle and Life Over Agency, also sent unlawful messages and contravened with Regulations 22 and 23 of the PECA, and they was fined £80,000 as well.
Great, thank you, Laura. And a timely reminder that the ICO regulates things apart from data protection.
Yeah.
So key thing here is it's electronic communications, and this is using the existing privacy and electronic communications regs, which in turn are based on an EU directive that's almost 20 years old now, the Privacy and Electronic Communications, the e-Privacy Directive from 2002. And in this instance, that's clamping down on things like direct marketing, where here we've got electronic communication taking place unsolicited, unasked for, and very often being done on an automated basis. So millions of messages being sent out. And this is, first of all, an example of the ongoing regulation and enforcement by the ICO on this, turning around and making fairly significant fines in relation to the sending of these messages. Bear in mind that very often these fines are weighted and calculated based on the size of the organisation being investigated. So that's why, you know, big organisation like BA, originally they were looking at fining them almost £200 million, went down to £20 million when, you know, after COVID, it's not quite as big an airline as it was. In this instance, they're looking at a marketing company where I'm sure for Leeds Works there, you know, £250,000 fine, that will probably be a significant sum for them that will sort of take a significant hit in terms of their profitability with having to pay that fine. And this is making it clear as well that we aren't just talking about personal data, it's just when it's processing of this contact information where the recipient hasn't, didn't want, need, or ask for the communication and receives it anyway. So it's a reminder that the old random communication practices of old are prohibited. But also, it's quite interesting when we look at the fact that the old e-privacy directive that the Privacy and Electronic Communications Regs is based on, that e-privacy directive is now at a European level being replaced because there is a draft e-privacy regulation that has been published by the European Commission. That will now have to make its way through the European Parliament and is likely to be adopted at a European level within the next year or two. Like GDPR, there will then be a couple of years where that then has to come in, like a transition period. And the e-privacy regulation will adopt GDPR's fines matrix. So potentially you could then be looking at the same multi-million-pound fines that are applied for breaches of GDPR could also happen then with regards to e-privacy. As to how whether that is implemented in the UK, we will have to wait and see. I would have thought it would be likely that something would happen with regards to the regulation of electronic communications, but whether it would look in the same form as what is introduced by the EU, we would have to wait and see. But as I say, timely reminder that regardless of what's coming down the track, the current law can still be enforced with teeth, as we can see.
Yeah, absolutely. I think I just wanted to add here as well, while we're on about text messages and kind of like phishing text messages as well. So I mentioned last week how I received a what I thought was a phishing a scam message from someone purporting to be the NHS vaccine. I can confirm that that was actually a genuine message, but I think it just highlights the risk of just basically all I did was I rang the doctors, I rang my GP and double checked with them, and they was like, yep, it's true, genuine link. But I think it just highlights the fact that they don't mind you checking. It's better to check than to chance it. So yeah, just a reminder there as well.
Indeed, and we were talking about this, Laura, weren't we? That I think the main thing to bear in mind, particularly with notification like that, I think everyone is patiently waiting. In Britain we love queuing, and this is, I think, our biggest ever queue, as the entire population patiently waits to get its vaccine. And in this instance, you got the notification and it turned out it was genuine, but you did the right thing by contacting the surgery rather than clicking on a link in a text message where you couldn't necessarily be certain of the provenance of that. But I think that the key thing is, contact your GP surgery if you receive a notification like that, or go along to the NHS vaccines website where you can book. And at the moment, I think it's it's .gov.uk/vaccine, and for NHS England, you can go on there and it says this is where you can book your vaccine. And at the moment, of course, you can only do it if you're on the vulnerable list or if you're above the age of 55. So whereas you've been able to go there to the front of the queue and you're not taken care of, there's still a few of us left in our firm here that we're still waiting very patiently for our vaccine, and hopefully it will come through in the next couple of weeks.
Yeah, hopefully. So moving on to our next one then. So this is in regards to the UK competition watchdog that are investigating Apple over unfair and anti-competitive terms for the app developers. So we spoke about this quite a lot over the course of our Digital Law News series, especially with our colleague Heather Anson as well, from Anson Evaluate, who helps us produce this webinar. She's come on a few times to talk about things to do with Apple and unfair and anti-competitive behaviour that they do. So this is now an investigation that's being carried out by the Competition and Markets Authority in the UK, and they're looking into concerns that Apple has abused its dominant position over distribution on Apple devices here in the UK. So it's thought that they have been cutting small businesses off from its desperately needed customers by making them pay more or giving them less choice in terms of the apps that is available on their store. So as well, France are carrying out their investigation by the European Commission into this, and their Apple are currently subject to legal complaints from Fortnite maker Epic Games in the US as well for abusing their market power.
Yes, thanks, Laura. So indeed, this is just an evolution of the story that we've talked about before, but it's clear that the UK regulator is now looking at this actively.
Yeah.
The Competition and Markets Authority, of course, is now, now that we're outside of the EU, is potentially able to move on issues like this around abuse of the market and a dominant market position more quickly than it could have done from within the EU, and therefore is investigating this. At the same time, at an EU level, we have the Digital Services Act package that looks at the regulation of what it calls gatekeepers, of whom Apple is likely to be designated a gatekeeper in that it provides access to business channels to businesses on its app store. So indeed, those developers like Fortnite. So we're looking at regulation in the EU. We've already got investigations in the US over this dominant investigation of dominant market position, and now the same thing happening in the UK. And it seems that in all of these jurisdictions and others around the world, Apple will be facing increasing regulation because of concerns over its use of that market position, which, I mean, to a certain extent, Apple has created this environment and has been able to do it, to use that position because it created a market where previously there wasn't one. But nonetheless, the dominance of that market now means that the regulators are gradually waking up to the fact that it may not necessarily be an entirely level playing field, and that's why we're getting increasing levels of regulation being proposed. So it'll be interesting to see what happens, what they decide to do. Will the UK take a similar position to that the EU takes through the Digital Markets Act? Will it go more down the US route? Will it try and hit somewhere in the middle? I think this is now what the decision for the UK. Once you're outside of the EU, what regulatory model do you intend to follow? So certainly not the last that we've seen of this story.
No, absolutely. I think this is one that's going to be coming up for probably the next couple of years, to be honest. I think we've mentioned this right from the beginning when we started this podcast, and now we're on, I think, the 33rd episode or something, so almost a year on, and we're still mentioning things like this, so probably not the end of it. So moving on to our second to last story then. So this is in regards to the Clubhouse app. And the privacy concerns that have been raised by users of the app when they sign up. So this is an article that was actually in the news probably about a month ago now, but Peter and I was having a discussion about this yesterday. So the Clubhouse app is actually labelled one of the most exclusive apps, and it's basically a social media app, a communication app where you have conversations with other people who have been invited to the app, and it's all done by broadcasted group video call. So instead of sending like text messages in, like written messages, it's all to do with like voice messages. So basically, I think what happens is you, if I'm right, Peter, you might be able to add to this after. It's basically all the people who use the app are invited to join a conversation, and when you are then sign up to it, they ask for permission to see not only your information but the information stored in your contacts as well. So they're gathering a lot of information, not from yourself but from other people as well, third parties who may not be aware that their information is being collected. And then stored on their systems as well. And I think another of the great concerns that people have over privacy is the fact that these voice conversations are being recorded, yet they don't seem to be publicly available for the users of the app to view. So it just makes you wonder where these recordings are being stored, and if people are able to see them.
Indeed. I think this is fascinating that Clubhouse has had fairly stratospheric growth. It's only about a year old, but has really come to prominence in 2021, largely because it's got roughly about 8 million users, about 2.5 million in the United States, and a lot of celebrities on there, and it's currently got that sort of fresh new feeling about it, where it's the cool new thing to be on.
Yeah.
And it, hence you've had odd people on there like Elon Musk and politicians. And the idea is that you can go into a room, there'll be other people in there, you can have a conversation, you can end up sort of standing on the virtual stage, talking to the people in the room. You can then invite other people in the room onto that stage to ask a question. It's currently audio only, not video, but I can imagine that the video will be coming down the line, given that we're all now using webcams so ubiquitously. But at the moment, it's those audio recordings. But the key things from a legal perspective, and this is where I think the developers had this great idea and they built it, and it's now doing very well. But they hadn't thought of some of the legal and regulatory requirements. And Laura, this is why we always say to our clients, guess what? You're in the UK, we have a Data Protection Act, and you should really be demonstrating data protection by design. This is where you need to have a data privacy impact assessment carried out at the outset that identifies privacy problems. In this instance, the guys behind Clubhouse, I mean, they're in California. They didn't have to worry about this. So they've now come up against, the rock and the immovable object. They've now come up against European data protection legislation. And the problem is, they are doing this practice whereby when you download the app, it then says, please give us access to all of your other contacts. And this is pretty standard with a lot of apps that you download. But the point here is that when it's come to social media, they very often try to back away from that without getting explicit consent from the user. Or certainly they've then changed the way they handle that data once they upload it. Because when you're then acquiring personal data related to people who aren't users of your app. Under data protection law, as we know, Article 6 of GDPR says you can only process data with 6 bases. One being consent. Well, if you've got if I've gone onto Clubhouse and it's taken someone's contact details from my phone, well, they've clearly not given their consent. I might have given my consent, but I've not given consent for them to take the people's information. The people whose information is stored on my phone, they haven't said yes, they're happy for that to go to Clubhouse. So you can't have consent. You've then got things like legitimate interest. Well, it's difficult to argue there's a legitimate interest there. You certainly can't argue that there's a contractual basis for it. You can't argue there's an overriding public interest. So none of those 6 bases within GDPR, under none of them really can you say, yes, we can take hundreds of people's contact information from the phones of every user that we have, and then start processing it. And the key thing here is not only do they then take that data, they then process it for the purposes of creating shadow profiles of people who aren't yet on the system. Now, Facebook got in trouble for this years ago, way before GDPR came along. They got into trouble for doing that in the EU. And basically, when you would upload a photograph, it very cleverly, using AI, started to work out who the people in that photograph might be. So at the moment, when you go in and it says tag, it will give you the box where it says, here's a face, and you can click on it and then tag that person. But a few years ago, Facebook had worked out, here's the person's face, and we think it's this person. And then for the people that you didn't tag, it would still take that photo and build up a shadow profile. The idea being that if that person did subsequently join Facebook, they'd be able to then go back and say, we now know that you were in all these other photos, and we can tag you in that, and we know who else you're connected to. And it was, in effect, therefore, it's processing a lot of personal data about someone without their consent, knowledge, or understanding. A really fundamental breach of those basic principles that underpin EU data protection law. So Facebook learned this rather costly lesson many years ago. However, the guys behind Clubhouse, who I understand, I think they came from Google originally, they had not understood these fairly fundamental points of EU data protection law. So they've run off and done Clubhouse, happy day, making lots of money, I'm sure. And now they've sort of realized, we have this problem. How are we going to address it? So that's going to be an issue in terms of, I'm sure they'll probably have to change how Clubhouse works for those who access it from IP addresses based in the EU. and potentially, I suppose, for any countries that have close trading arrangements with the EU as well, so potentially Japan, Canada, the UK, they might be saying, well, look, our data protection laws are similar to the EU's, which is why we've got adequacy. So there could be problems there for them as well. So this will be interesting to see. It's going to be a major challenge, because when you've designed your platform to work in a certain way, and then you have to start sort of fiddling at the underlying assumptions upon which that platform is based, it can sometimes be a very difficult, complex undertaking to then change how that platform will operate in certain jurisdictions. So the advert here is to say, carry out a data privacy impact assessment at the start. Don't suddenly wake up to data protection issues further down the line.
Yeah, I think it's important to mention here as well, with you saying that there's obviously the 6 legal bases to collecting the data. Once that data is collected, we all know that when you collected the data directly from the data subject, you have to at least provide the information under Article 13 of GDPR, and I think it's Section 93 of the Data Protection Act, to the data subject, and that's basically the information that needs to be in your privacy notice on your website or given directly to the data subject. But I think a lot of people forget that if you do collect data indirectly from a different data subject that is about the data subject and they don't have knowledge of it, you still have the requirement under Article 14, and I think it's now Section 94 of the Data Protection Act, to provide them with basically the same information. Not as much information, but it's basically the same. So without them knowing that you're collecting that data, that proves very difficult to do so.
Exactly. And that's just illustrating the fact that, yes, we are looking at some fairly major principles underpinning data protection law here. And it's going to be a difficult exercise for the platform to adapt to that.
Yeah.
The other question to ask is, will they then invest in taking those steps, or potentially would they turn around and say, we aren't going to provide Clubhouse in the European Union?
Yeah.
And when you've got millions of users all around the world, are you then necessarily going to turn around and say, we will then expend X number million of dollars to update the platform to make it do this? And that is the increasing challenge. Organizations increasingly look at the high level of regulation in the EU and say, is it really worth it? And Clubhouse is now faced with the same calculation in this regard that Facebook and Google and Apple and others have had. And how they choose to approach that will be an indicator in terms of, as the EU's increasing level of regulation keeps increasing, does it remain profitable and cost effective to jump through that hoop in order to access the EU's single market? But I should add as well, for those interested in Clubhouse, and I'd like to just sort of express our thanks to Matt Chorley at Times Radio, who put together an interesting show on this earlier in the week, and he also put that out as a podcast. And it was interesting because he was talking about all the politicians in the UK who are going on to Clubhouse, MPs who are using it to speak to their constituents and their local campaigning teams. And clearly this platform is therefore already getting a good following in that regard. The other thing that they talked about is the fact that at the moment with this platform, it is invite only, and it's very much a sort of space where it's quite positive and a different way of engaging using audio, live audio streaming, rather than Twitter and its 240 characters. But originally, when people first went onto Twitter, that was a nice bucolic world of people exchanging opinions and communicating across borders and across huge amounts of space. Everyone was loving it. Same thing with Facebook when that was early. And then, of course, after a while, these platforms often tend to sour, unfortunately. And at the moment, while Clubhouse is clearly a lovely world of fluffy bunny rabbits and everything is wonderful, you wonder, will it now unfortunately follow the route that so many platforms have followed? Instagram's had the same thing, where it starts off great and over time you sometimes find it's no longer the nice positive space to be in that it was. So it's enjoying its current time in the sun, but let's see how long that environment is preserved, at the same time as they end up having to then deal with these very real legal and regulatory issues as well.
Yeah. Absolutely. So moving on to our last story of the day then. So this is in regards to the potential government plans to reform data laws in order to spur economic growth. So the Digital Secretary, Oliver Dowden, actually spoke on this and has said that Britain should take a slightly less European approach to privacy, referring to the EU's General Data Protection Regulation. And he suggested that they should focus more on the outcomes that we want to have rather than the burdens that GDPR basically puts on us. And he has then moved on to say that as we move from sustaining the economy to the real drive for growth and goodness, we're going to need a huge amount of growth. Digital and tech are absolutely at the forefront of that. And he's seeking to set out where we are going to go with data now that we've left the European Union and are not subject to the EU jurisdiction. So I think this was just a good story to mention at the end. Nothing has actually been announced in terms of if anything or what will be changed. But I think it's just a food for thought.
Indeed, thank you, Laura. I think this is indeed a fascinating story, because now that the UK has left the EU and we have the UK's free trade deal with the EU, I think a lot of people expected a sort of bonfire of regulation would happen pretty soon afterwards. And I know that quite top of a lot of people's lists of, well, we can get rid of this now. GDPR is always quite close, let's face it. Everyone thinks, oh, well, let's get rid of this now. And unfortunately, it's not quite as easy as that. You and I have talked at length on this podcast about adequacy, and the fact that we've now got adequacy decision from the European Union towards data then being able to flow into the UK. And that means that personal data of EU citizens can flow into from the EU to the UK, and indeed those in the UK who are accessing data on servers in the EU, as an awful lot of people in the UK are. If your servers are based in Dublin and you're accessing either your Apple servers there or Microsoft or Amazon, so much of that infrastructure is based in the European Union. At least with that adequacy decision, those data flows can continue unaffected. But that adequacy decision is underpinned by the fact that the UK has written GDPR into UK law in the UK Data Protection Act 2018, and there is the UK's GDPR in effect in place. And the point here is that if you then start to whittle away at what that version of GDPR we have in the UK is and what it does, that puts that adequacy decision in jeopardy. Yeah. And for those who might say, so what? I would say, well, if you've not got the adequacy decision, you've got to rely on binding corporate rules or standard contractual clauses. And Laura, you and I were looking at standard contractual clauses earlier today for a client. Yeah. They're 50 pages long. If you want to have that in every single data transfer agreement that you have with an organization in Europe, and you want to deal with all that paperwork on top of everything else, well, it's a fairly heavy burden to have to put in place if you're doing that with every single subcontractor you've got in the EU. So that's why adequacy at the moment, global pandemic, dealing with Brexit for a lot of our exporters is concerned. That's why having that additional burden is something that ideally we don't want to be dealing with right now. And consequently, nice idea to think, let's put GDPR on the scrap heap, or take an axe to certain parts of it. Can we get rid of some of these data subject rights? Can we bin the idea of subject access requests? Well, the minute that you start getting away with that, the more that you're then in the world of that adequacy decision is withdrawn, and then the burden then falls on businesses relying on data and infrastructure based in the European Union. So, in the long run, it might well be the case that we can reform parts of GDPR. I mean, the EU will end up reforming GDPR itself. I think, I can't remember if we talked about it last week, but there was one German MEP who's already turned around and said that he thinks that GDPR needs to be reformed because it doesn't adequately reflect the use of data in artificial intelligence, blockchain, and therefore it needs to be updated to reflect these continuing emerging technologies, which were very much in their they've matured an awful lot in the 5 years since GDPR was passed by the European Parliament in 2016. And therefore, that there is the UK may diverge in that regard. It might go down a different route with AI and blockchain, but certainly with regards to that fundamental GDPR as is that's written into UK law, it's very difficult to start cutting back on that. So I applaud Oliver Dowden for looking at this. I think the government should be looking to see what areas it can potentially streamline. The aim here, don't forget, is, as you quite rightly said, Laura, is growth. We're looking at potentially 7% growth. 7% growth for the UK next year. Fantastic. That's what we need. The more that growth, the more your tax revenue is, the more you can put money into the NHS, the more we can put money into building back on the back of this huge amount of public debt that we've now got because of all the schemes that have been thrown in this year. But it's an applaudable reason to try and deregulate to aid that, but GDPR is a very difficult branch to start pruning back at this point. But if the government wants to look at that, we stand ready to work with them and help them on it. Let's put it that way.
Yeah, absolutely. We'll be ready. So that is everything we've got time for today. So as usual, we just wanted to remind everyone of our special offer we have on for our listeners. So this is our GDPR compliance manual for legal practices, which is down to £99, so around 50% off. So this includes forms, templates and checklists, basically helping you and your organisation become compliant with GDPR. So it's basically telling, rather than telling you what GDPR says, it's telling you how you can interpret GDPR and how you can actually bring these data protection practices into your organisation and how you can improve the way you're protecting your data as well. So is there anything you wanted to add on that, Peter?
No, you're absolutely right there, Laura. GDPR is great at telling you, achieve this standard, and it doesn't tell you how to.
Yeah, exactly.
This manual helpfully sets it out for you in black and white on the page. So forms, templates, checklists, in plain English. I'm pleased to say that we pruned out all of the legalese. You don't need a law degree. You don't need to have 10 years worth of expert knowledge of coding and programming to understand what we're talking about in there. There's a nice big glossary as well, needless to say. But it's all designed to help any organisation, well, law firms and regulated practice in particular, but there's a lot of helpful guidance in there for any organisation if you're looking to get a handle on what your data protection compliance needs to look like.
Yeah, absolutely. And also we wanted to just say a big thank you to Anson Evaluate as well for helping us produce these webinars. So for those who don't know, we do speak about Anson Evaluate quite a lot here, but we just wanted to basically tell you a little bit more about them. So Anson Evaluate is a training and webinar and consultancy service business. So they provide a lot of training to do with data protection and other areas as well. To different companies in the form of webinars, in-person training, conferences, whenever everything is back to normal, as well as doing some consultancy work. So if you are an organisation, a business who are wanting to run some webinars, either in-house or basically for some of your staff, or just a public webinar for other people to register, Anson Evaluate can help with that as well as carrying out training. So I have put their website on the screen and the email addresses. You can get in contact with them as well.
And there's also, I believe, on the Anson Evaluate website, a video on their blog, but for those that are interested, that looks at law tech and a student project that Anson Evaluate coordinated with law students around the UK and indeed a few law students overseas to basically teach them how to code and then come up with systems that would help in delivering programs that could help people access justice online. So they put together a online program using Python language that would allow, which is the same language that is used to code Facebook, I believe, and they put together an easy-to-use system so that if someone wanted to, say, get help with regards to immigration services, they'd be able to access it. And there's a video on there that just takes you through, the students talk you through the work they did, and they give a demonstration of the systems that they've built. So a great example there of how Anson Evaluate is working with tomorrow's lawyers, the next generation, and providing them with the skills that will be essential in the digital economy.
Yeah, absolutely. And I think there is some more information on the Anson Evaluate website as well. If you are an organisation who might be able to help the charities or anything that are actually wanting to offer the services that they have created for charities to help people who are struggling with the access to justice as well. So there will be more information about that on the website. So yeah, as I said, that's everything we've got time for today. So thank you once again for everyone for listening to this webinar and podcast. So it is available on demand as usual on all the podcast and webinar platforms. And we will be back again next week for another episode. So thank you again for listening, and goodbye.